Good morning, everyone. I know it's a rainy day, it's a rainy season, but I hope you are safe. Welcome to Strictly Legal on WESN Content Capital. I am your host, Rondell Donowa, attorney at law. Once again, I'm happy to be here. I'm happy to be alive. I'm happy to bring the law and you. Hope you are doing well, and you can stream us on WESNCC.com, as well as our traditional media and podcast at Strictly Legal with Rondell Donowa. Today, we are going to speak about strike action, industrial relations. We have heard so much information in the news with respect to, most recently, tutor being, basically the Ministry of Education being granted an injunction against tutor for such strike action. What is industrial relations? Whether those strike actions is justifiable and whether it is legal. Of course, what are the parameters and the law surrounding these actions? Of course, you would want to know whether it is safe and what is the underlying interest with respect to students, teachers, as well as essential, non-essential services, etc. There's a lot. And today I do have in studio Vivek Lakan Joseph, who is a trial advocate with 12 years experience, and he's a founder and principal attorney of Vivek Lakan Joseph and Associates, a boutique full-service law firm in Woodbrook, Port of Spain. In addition to broad high court litigation portfolios, he is an IR specialist with heavy industrial court practice. He's currently engaged as counsel for a variety of corporate entities for the provision of legal services and advice with respect to both contentious and non-contentious matters. And he also prides himself on advancing proactive and practical solutions, as well as providing personalized attention to his client tailored to their specific needs. You may have seen him a lot on television, or maybe his learning on different topics relating to industrial relations. So I'm very happy to have him in studio. Good morning, Vivek. How are you?
Hi, good morning.
I hope I pronounced the name properly.
Yes, yes, Vivek. And thank you very much for having me on the program and for such a generous introduction as well.
Thank you so much. And I know it's so much to discuss. So let's get right into it. Now let's start with this this current issue, Ministry of Labor versus tutor. I know in the news just last week, the Ministry of Labor would have been granted an injunction in the dead of the night, as they call it, on Sunday evening against tutor for an industrial, or whether it is a day of sickness that they would have, or rest on reflection, I believe. Yes. And you can tell us more that they was going to engage in on the Monday. So give us an overview of what is that case about.
Okay, firstly, you're absolutely right. In the dead of the night, we have the Minister of Labor who goes to court. He gets an injunction directly from the industrial court, and it's against tutor, who would be the recognized majority union representing teachers in Trinidad and Tobago. There are levels of importance that attract to this matter, especially because it comes against a backdrop of very aggressive negotiations between tutor and the government. Now, there are so many different layers to this topic, and the case is really not the simplest of ones, but key features would include industrial action being taken by a class such as teachers in Trinidad and Tobago, and whether or not that industrial action is even permitted in the first place. Yeah. Outside of that, we have other considerations as to whether or not the injunction ought to have been granted. What is the test that applies in law? And perhaps most importantly, where do we move forward after it is that we have this court action? So that is really just the initial feature of the case, but stemming from that, perhaps we can go into that class of teachers and where do they fall in Trinidad.
Indeed, and that would have been my follow-up question as to, okay, yes, we understand that there are a lot of layers, but are teachers an essential, is the Teaching Commission an essential service? Let's put it that way.
Right, so people use this quite informally, and there's nothing wrong with that too. As a service, they're certainly essential, but we are governed by the Industrial Relations Act, and there's a listing, a category of list as to which entities actually fall under that category of essential services. Now, while the teaching service isn't specifically named there, the Act does make provision for them elsewhere, and that provision expressly prohibits the teaching service from engaging in industrial action, including strikes.
So, therefore, that leads to the other question. Okay, so are you saying that it's illegal for teachers to strike?
So, especially when you have a matter that is before the court right now, it is sub judice, and normally I wouldn't go too much into detail or attempt to make any pronouncement on it. But in my view, the law is very clear. We have an Industrial Relations Act. Certain classes are prohibited from taking industrial action, including strike, go slow, and the teachers do fall into a category which is prohibited from taking industrial action. So at face value, certainly, once it is deemed to be that the action they have taken is industrial action, I would say that is prohibited under our law.
And when we say industrial action, give us a sort of a definition of what really is industrial action for the purpose of this.
We do have a heavier legal definition in the Act. To maybe break it down a little bit simpler, and this is of course in the context of unions, employers, employees. The hallmark features would really include actions by a party which compels or attempts to compel another party to either agree to terms of employment or to comply with their demands. And when we look at this with the backdrop of the aggressive negotiations with tutor and the government, we really see that it can certainly be interpreted that if it is that there's a rest and reflection period, that this may be deemed to be one such action where it is that they're trying to compel the other side, in this case the government, to take certain action because, look, the consequence may be so dire if we, the government, do not respond. And I think that may have been the thought process behind the movement.
But is it that rest and reflection is a definition of strike action? Is that one of the examples of what a strike action is?
So I think as the words for strike action, the key feature of striking would really be the cessation of work. And what I have seen from the industrial court so far, and this is subject to any judgment, is that they've classified it under the wider bracket of industrial action. And industrial action has that broader definition where, depending on the nature of what has actually transpired, it may be deemed to be industrial action, which is the broader category. I would say that striking is a subcategory that is a part of the industrial action. And I would say that no matter how tutor may try to slice it or dice it, as it stands on its face, if it is a call for teachers to essentially not come out to work, and it's for a purpose, and it's with the backdrop of these negotiations, it is likely to be deemed to be some form of industrial action, which is the wider category.
And really and truly, it's as a result. So what the elephant in the room there is wage negotiation.
Yes.
Yeah,
that's exactly it. And this brings up, and I'm so happy that you mentioned that, because it's such an important issue to treat with. We have teachers, I mean, a respected profession. What they do for society is invaluable. We're talking about children, our future, and they're saying, well, look, we need to be fairly compensated. We need a wage increase commensurate with inflation, the increased cost of living. But at the same time, we have a government who perhaps is also reasonably saying, well, there must be limits that we can attract to any such increase. So where do we really strike that balance, and what is the real recourse that teachers may have if it is that we really have a law or legislation which actually expressly prohibits that type of action? And I think that's one of the reasons why the topic is such a heavily debated one as well. And we're looking at the balance in interest. We're looking at the interest of the child, the right to education, yes, because that's a constitutional right. But it's also the right of the teacher to be compensated properly for their time, their talent, and obviously providing a sound education to the students. Absolutely, that's spot on. The only thing I would want to add is the genesis of this case that was brought by the Ministry of Labor is that the minister has a discretion where, depending on the nature of any action that is taken, if it is that the minister deems there to be any threat or harm to what the minister deems to be the national interest, then the minister is allowed to approach the court and ask for an injunction to prevent either the threatened or the actual action itself. So that even a more global question arises, well, what is really the national interest? And is the minister correct in saying the national interest requires that the court stop tutor from continuing in this action? So once again, perfect that you've raised the individual rights and the right of the child to education, the right of the teacher, perhaps a fair compensation and fair value for the work which is undertaken. But just as important as well, the national interest point, because we're looking at it, I think, more, in this case at least, from a macro rather than a micro level.
And we understand, or we understood that this injunction was granted ex parte, and of course meaning ex parte meaning without the other side being present to either defend themselves or actually provide some sort of response. Now can you explain why is it that the courts, in any proceedings, would grant an order ex parte without another party being present in the interim?
Right. So an ex parte application is made in certain circumstances, usually where the law expressly provides for it. The general trend now in our court system and in the common law would be that both parties be given that right to be heard at the same time. So not ex parte. It will really be only in the most limited of circumstances. Strangely enough, the provisions of this Act, this Industrial Relations Act, caters for the minister to make this application on an ex parte basis. The thinking behind it from the learning, which I've read so far, suggests that the matters may be so urgent or so important, given the macro level, this national interest point, that there may not even be time to necessarily serve or to wait to afford the other side, in this case the union, an opportunity to be heard immediately, but rather it gives a direct line from the minister to the court to seek that injunction. Now, that is not to say that fairness does not dictate that the union also doesn't have an opportunity to respond, but certainly the design of this law is that the minister brings this application ex parte. So that is actually what is required in these circumstances. I wouldn't say that there was anything underhanded that they have gone on an ex parte basis, but certainly that is what the law would have made provision for.
And of course you indicated that the law would also make provision for the union to respond.
Yes.
And of course when the union responds, it does not necessarily mean that an injunction will be in perpetuity. It can be lifted.
Absolutely. Now, I have no indication as to what stance the union would take. The industrial court tends to take a very practical look at matters. It is not unusual for the parties to speak if it is that the union wishes to adopt a certain position, depending on what we have already described the legislation as providing for. Then the parties can discuss and find a way forward. Certainly this nature of litigation, I don't think really assists either party. Once it is that everybody bats in their respective creases and doesn't step out of the lines of the law, then there's no reason why the negotiations can't continue in harmony. But if it is that the Minister of Labour, I suppose, is of the view that extra protection would be needed, and he maybe doesn't, the Minister maybe would not have the level of trust that further industrial action may not be taken, then he may insist on having the injunction preserved.
And one would assume that this particular interim injunction protects the ministry from further strike action that tutor may want to undertake.
Exactly, and to piggyback off of your point, it wouldn't just be the protection of the ministry alone and the general industry, it's to the wider society. Because even if teachers are not necessarily classified specifically as essential services under our law, there's provision made for them not to take industrial action for a reason. And I think informally the topic is how vital the teaching service is to the wider community. And that, of course, is not to relegate the teaching service, because we all have the utmost respect for the entire category of teaching. But when you look at essential services generally and the wider category, those Section 69 entities where the law provides for, they are fundamental. Everything goes back to fundamental rights of society. And that's why when we look at essential services, you see water, you see electricity, you see certain aspects within the public sector generally. Health is, of course, extremely important. And I have done quite a bit of research since the action as well to solidify what the court's views are. And when it is that the court makes a pronouncement on what is in the national interest, you see very interesting language which is used. The court sometimes uses language as this may have a crippling effect on society, a paralyzing effect on the operations of society in the medical field, so that
So that is a legal test that they use.
well, as to whether or not there's an infringement on that national interest. And that goes to show you how high that bar really is that the minister would have had to cross that threshold. But of course, if the law says you're not allowed to take industrial action, and it has been shown to be that you have, perhaps the industrial court may have had very little discretion in exercising their rights to grant that injunction.
Now, let's say tutor or any other union decides to breach that court order and proceed with industrial action. What are the consequences? Does that obviously now become a criminal offense?
Yes, you're absolutely right. They're industrial relations offenses and they're criminal offenses. And what our legislation does is it breaks down into very specific detail, depending on who you are and what you have done, a variety of offenses that go from fines to terms of imprisonment. So not to make light of it, it's extremely serious business that we're dealing with. And the language of our law also captures wider categories as well. So even if it is that you are not directly the president of a union or a member of a union or a teacher or an employer directly, even if it is that you are to encourage that industrial action, for example, for essential services, that could be an offense as well.
Well, then who is held responsible? Is it that the entire union, the president, the teachers, because obviously it now means that this becomes mass litigation?
Right, exactly.
And that's practical.
Right, and that's perfect. So that's the practical side of things now. Would it be practical to have these consequences go against a wide number of teachers? And the law also provides that sometimes the sanctions would not be automatic. The law provides that if it is that a union or workers even potentially take industrial action which is not legal or in accordance with the act, that the consequence could potentially even be that the employer treats that breach of the employee as to the root of the contract, fundamental to even terminate. Now that is not really the case for essential services, because we can't have members of our essential services have all their contracts terminated. But it just goes to show how strict industrial action is. And you had mentioned as well, who is really responsible? We have employees who may be members of the union, and we have the union, we have employers, we have representatives. It is serious enough that when we speak of industrial action, it's not just any random union. You have a recognized majority union. In this case, for example, it would be tutor. Now, if it is that tutor, or rather, let me not use any names, if a recognized majority union, rather, were to effect such a breach, it is open for them to be declassified as that recognized majority union. So the theoretical consequences are quite high, which is why the letter of the law is so important, and making sure that entities always follow the design and the provisions as to what the law caters for.
So therefore, the sanctions imposed does not necessarily have to be custodian, or it can be fines, or it can be, as you said, consequences such as declassification of the union and obviously stifling their authority to act on behalf of the majority.
Exactly, and those would be subject usually to further applications. I wouldn't say it's any automatic sanction. I think historically, from what I have observed in practice, it's not to say that the consequences have automatically followed or anything like that. It's usually, like I said, subject to further procedure. And it may not be in the best interest usually to have something so nuclear like declassification done or so. Right? I think a court may be loath to exercise some of those options, not to speak for any court, of course. But the goal would be that the parties can reach an amicable resolution without the need for this kind of litigation.
Indeed. So let's. I mean, we've been speaking about essential services. Who are essential services? So let's go into. I mean, we've dealt with tutor. We've understand that the teachers are, while it's not classified as essential, it's sort of understood to be an important essential service.
Yes.
So let's deal with what are other types of essential services
yes, absolutely. I have my handy list that has everything right here for you. But it would be the same things that people have already expected. But I don't want to bore with law.
Indeed,
but we have a second schedule of the Industrial Relations Act. There's a full listing, but it goes from electricity, water and sewage, telephone, communications, fire, health, sanitation, civil aviation, across the board, those would be the main categories.
But you know, this sounds cliche because you mentioned water and sewage, you mentioned electricity, but water and sewage are the main litigants as well in the industrial court with action. I mean, we have what is possibly been looming with restructuring of jobs,
yes.
PSA, basically involving industrial actions or pushback. So how can these essential services move around the law to actually engage in industrial action? Because you really see, the only service that you don't really see industrial action taking place are the protective services. Maybe they do it in a different way, like the full day of policing, we can probably infer. A couple of years ago.
Right.
The roadblocks.
So that's it's such an extremely interesting take as well. And when I use the term industrial action, certainly, I want to exclude industrial proceedings generally before the court. So I have seen, and to make it clear, these essential services are prohibited from taking industrial action such as strike. Employers can't exercise lockout for those essential services. And that category, I think, in law is really not up for dispute. But when we look at the Water and Sewage Authority and so on, any actions that they could bring, it'll have to be classified outside of that industrial action scope. It's going to have to be that legal proceedings are filed, for example, as opposed to what we were speaking about, where we have other means of action outside of the court's doors entirely.
But in practice, I mean, we are seeing different reports, etc., with respect to all forms of action or picketing. So is it that there are loopholes in the law in terms of defining what is, as we said earlier, industrial action, or whether sit-out, or whether a matter of just gathering in front of the offices of the executive is not considered industrial action, but it's more a matter of just gathering?
Right. So this is where we look at as a feature where we're trying to balance what are the provisions of the law versus what really happens in practice, and how far do you really take it. And I love that example. If you gather outside the door, it could well be that everyone is saying, well, we're not really working. And if it is that we're not really working,
that's loitering.
Outside of that as well, if it is that you're demonstrating, well, there's a cessation of work, or that we're threatening not to continue work because we'll continue gathering or picketing and it's during work hours, and so it may well fall back in industrial action under that wider definition that we spoke about earlier. And then the next question is, well, how far do we take these practical consequences? Is this necessary for the Minister of Labour to intervene because we have 20 people doing this on one day? Probably not. That may not be in the national interest. But what happens when you have a wider group, and how far is this reported from the employer to the union? Those are things that are open and available to employers if it is that there is illegal industrial action taking place. If it is, though, that the employees and the union, the recognized majority union, are going by the letter of the law and are bringing proceedings in line with what the law caters for, then theoretically there's no real issue there.
Indeed.
But the restructuring, like you mentioned, was a good example of that, because I think that's hot off the press. We're familiar with what's going on in the news.
I think that's obviously a topic on its own that we need to discuss in our second part of this program. But let's switch, because I know the time goes really quickly here.
Right.
So let's switch in terms of private entities. Are private entities unionized, or are they subjected to the same principles as a public entities? Let's touch on the difference, if there's any.
Absolutely. Most of the essential services, as an example, that we have really seen, essential services that we will look at with a public law lens on, a public lens, and we see like water and sewage, as we have been speaking about in electricity. The majority of those things almost entirely are within the public sphere. But then you have civil aviation that also forms part of an essential service. Private entities could be included in that. So there would be some level of overlap when we think of essential service providers that can impact upon private entities as well.
Is it banks? Does banks as a private entity form part of an essential service?
The central, actually, specifically under the same section 69, the central bank does. So where we have prohibitions as to whether or not you're allowed to go for industrial action, the central bank and members of the central bank are, as opposed to listing the other banks privately. They would be subject to different rules. But the wider question with respect to private versus public is a great one. The hallmark of this with respect to industrial action is that our law makes provision for whether it's the employer, the employees, or the recognized majority union to take industrial action, but within very, very strict confines of the law, and that includes private entities as well. So that means to say that whether an employer is interested in a lockout exercise, or whether it is that the recognized majority union in the private field is going to encourage or assist or engage in a form of strike, it absolutely can be done, but there's so many different layers, as we spoke about earlier, as to what is proper industrial action.
But then in terms of private entities, let's say, for instance, a law office or maybe an office, that a doctor's office or whomever, are their employees allowed to strike, or is it that they must be part of a union or recognized union to strike, to engage in industrial action
with respect
for these small businesses?
With respect to strike and lockout, and so you really will be confined to that recognized majority union aspect.
So you're saying that basically your secretary can decide to strike on her own?
Well, there's certainly consequences. Just to give an example, the Industrial Relations Act, which is what we are bound by, actually makes provision for notice to the other parties, how the union is to go about exercising these options, the timelines. It's usually in reference to an intended trade dispute which must be reported to the minister. So it gets a little bit more complex. I would say that if it is that you're in the private sphere, you're not unionized, and you're taking certain action which can be deemed to be industrial action, it could be very dangerous, especially because of the legal consequences.
So therefore we are saying that both private and public entities, they are bound by the same Industrial Relations Act or the same procedure in terms of how strike actions are
Absolutely, that's correct, yes. And the industrial court has a strong hold of that as well. And we see a lot of cases where entities may not have realized that by virtue of the action they're taking, they may be undermining their own position in their job security. So that's why it's always important that the entity, whether it be employer, employee, union, well, unions are professionals in their own right, but certainly the employers and employees have to take proper advice before taking any kind of action. And it goes both ways.
Yeah, it does. It does. Vivek, unfortunately, we are definitely out of time now, and I know
that's impossible. We've been speaking for no more than 10 minutes.
And this is what we always say. Time goes really quickly, so I know we will definitely have to come back again. Just before you leave, anything else you want to put forward?
Only to say that these are definitely interesting times. I always encourage viewers, and I know you have a very wide viewership. You always have to stay within the letter of the law. And I'm happy to come back on your invitation for our round 2 of this discussion.
Yes, indeed.
It was very much a pleasure.
Retrenchment. I know that's something that is on the burning topic, and that's something that we definitely have to discuss.
Excellent.
So thank you so much, Vivek.
Thank you for having me.
Again. Thank you. Guys, you have been watching Strictly Legal. Vivek Lakan Joseph speaking on industrial action, strike edition, and of course, stay tuned. On next time, we will be speaking on the restructuring process, retrenchment, the legalities, etc. So thank you so much for watching. I leave you with this quote: ask not what your country can do for you, but what you can do for your country. Good God bless. Thank you. Bye.
WESN.
Join me, Sule A. Joseph, as I delve into the day-to-day psychological issues plaguing our society. We will discuss behaviors that encompass the biological influences, social pressures, and environmental factors that affect how you think, act, and feel. Site, Thursdays at 11:30 a.m., only on WESN, Content Capital.
I'm here with Andrew Lewis, sailor. Andrew, thank you so much for joining us.
The most beautiful thing about sailing, in my opinion, is it's where it was, originated from. It was a form of transport that was allowing people to connect different parts of the planet. and sailing today has become many different ways of life, but I have chosen the pathway of the Olympic Games.
For women to feel confident, we have to feel sexy. That doesn't mean outward appearance. It could be a mental state, it could be a physical state, it could be an emotional state. And if you choose to be liberal, and if you choose to be conservative, that is up to you. I just give you the space to choose whatever you want to do.
What's up, Doc? Tuesdays and Thursdays here on WESN, Content Capital.
Let your voice be heard. Call Madam Fix It on WESN, the only place that effectively helps you with your woes. Having problems getting onto government agencies, water woes, NIS and pension problems, potholes, and much, much more. Call me, Madam Fix It, every Monday, Wednesday, and Friday, right here on WESN. Let me fix it for you.
I am Mahi Sekas and you are watching WESN, the Content Capital.
I am Kemuel Pascal and we are WESN, Content Capital.
With society plagued by a host of issues, with debates surrounding our urgent concerns falling short, with questions of our future not always being answered,
the conversation continues. Join me, Kemuel Pascal, as the voice of the youth comes to life. We will confront the controversial topics of today's world to gain answers that are key for a better tomorrow. One and One with me, Kemuel Pascal. Wednesdays at 10 a.m. Only on WESN, Content Capital.
I'm Andy Johnson, and you're watching WESN, the Content Capital. The issue, the continued rise in the price of flour and its impact on the cost of living in Trinidad and Tobago. How should we go about it? I want to ask you, what has been revealed to you about the state of vulnerability in the country because of this exercise and because of what we're going through? Is the government losing the war on the vaccine front?
The discussion should revolve around the common good for the greatest number of people in Trinidad and Tobago.
How do we inculcate a sense of respect and regard for people who may not be of your own political ilk or persuasion?
The communities are now being used by political opportunists. So
when the tables are turned, it's the same way. Okay, this has been 10 questions. I'm Andy Johnson, and we'll see you next time.
Come travel with us as we explore Diwali across the globe. Diwali is celebrated in many countries worldwide, but do you know the traditions and practices of each nation? From Guyana to Australia, WESN presents Diwali Passport, October 3rd to October 23rd, with replays on October 24th. It's Diwali Passport, a WESN exclusive.
I am Denise St. Clair and we are WESN, the Content Capital. AM Prime on WESN, the only place from 6 to 7:30 a.m. where you can get the most analytical and thorough interviews and regional reports.
The Barbados Labour Party, led by the Prime Minister Mia Motley, once again able to achieve a clean sweep in yesterday's general election.
I think a lot of people have underestimated the power of Tobago nationalism.
If the government is afraid to say it, I, Martin George, I am saying it this morning on your show, Andy, there will be no carnival before Ash Wednesday.
Grab a cup of coffee and start your day right watching AM Prime with Andy Johnson weekdays from 6 a.m. Only on your content capital, WESN.
I'm Sean Michael Small, and we are WESN, the content capital.
What's the best way to grab the attention of viewers?
Please exercise more patience. You have to be kidding me.
Doing what we do best. I'll say at the very least it's a conspiracy of laziness against the people.
Join me, Keaton Shaw.
And me, Sean Michael Small, for Talking Point.
Weekdays from 8 a.m. to 9:30 a.m.
We go in depth on the trending issues and engage the most controversial newsmakers
as we get them to account to the people for their actions.
You can't go to the government with nothing. You can't go to cabinet with an empty hand, with a wish.
I'm glad that we're having this a sober, mature discussion.
In the present situation, I expect a continuation of the chaos.
Join us for the discussion, Mondays to Fridays,
only on WESN,
the content capital.
I'm Keaton Shaw, and we are WESN, the content capital.